All right, it is 12:30 and we're going to get started. Thank you all for joining us and welcome to week 8 of the Bressler, Amory, and Ross COVID-19 webinar series. What businesses need to know in the wake of COVID-19, corporate and IP issues. And you can, quite frankly, it's amazing that it's week 8 and you can tell by, the hair's getting a little longer, the beards are getting a little scruffier, and while we may have our suit jackets on top, it's all sweatpants and slippers below. So it's truly been an interesting experience, and I think we've got some really important topics for today that are, quite frankly, at the forefront of things that just about every business is dealing with, and that's been impacted by this global pandemic. Today we're going to start by talking about the Payroll Protection program, what's happened, and quite frankly, what do you need to know to make sure that your loan is forgiven? We'll be discussing mergers and acquisitions, what your contracts say, what language you need to be looking at, what is just so relevant in today's situation. We'll talk about creditors' rights and workouts, and we'll focus on what companies need to be disclosing during COVID-19. What do our public companies need to do in compliance with SEC guidelines and other regulations? And then finally, we'll be discussing your intellectual property, how you need to protect it in this new world, and what you need to know, quite frankly. We have quite the distinguished panel of guests here to join us, and I'd like to thank them all. Tobias Ziegler, one of our principals, was going to join us, but unfortunately cannot. But thankfully, we've still got quite the panel. Tamara Gungazi is an associate in our corporate and securities department. She's focusing on securities and regulatory issues. Jessica Gonzalez is an associate in the firm's cannabis and intellectual property group. And Jessica counsels corporate and individual clients on intellectual property, procurement, prosecution, protection, and enforcement of domestic and international trademarks. Jordan Levine is an associate in our corporate department. He focuses on corporate and commercial transactions, including mergers and acquisitions, and general counsels for startups. And then, as I mentioned, Tobias unfortunately can't join us, but the team's here, and we're going to make sure to bring you all of the relevant and pertinent information. So, Jordan, I'd like to start by talking about the Payroll Protection Program. This has been, quite frankly, all over the news, and it seems every time I turn on the TV or pick up a newspaper, I'm getting different information. This sounded like it was supposed to be for small businesses, and then we heard about these massive conglomerates that were getting these loans. It sounded like there was plenty of money to go around, then suddenly there was no money, and now suddenly there's money again. Can you kind of just walk us through what the current state of affairs is and where we stand?
Absolutely, Evan. So the first round of these Small Business Associations Payroll Protection Program involved a $349 billion funding. As you can imagine, this amount was totally over and sent out within 2 weeks. The second round, which is $310 billion, is currently being issued out, and we expect that to be done fairly shortly. I mean, it could be any day now that that money runs out. There's been talk about possibly a third or fourth round, but nothing is set in stone yet. We do have some pretty fresh statistics on how the money in the first round was distributed. The average amount that was approved was $206,000, and 74% of the loans were under $150,000. So that gives a pretty clear picture that most of the recipients under the first tranche were small businesses or sole proprietorships. But there also was a large swath, about 24%, that received between $350,000 and $1 million. The top 3 states that were approved for loans were Texas, California, and Florida. We're somewhat surprised that New York was 4th after Florida, since New York has seen the brunt of issues as a result of this coronavirus. But New York was ahead of Florida in the amount of approved dollars under the loans. The top industries that received the loans was also quite surprising. Number 1 was construction. Number 2, professional, scientific, and technical services. And 3, manufacturing. We would normally think that accommodation and food services, which would include bars and restaurants, and retail and wholesale would be receiving a lot of the money, given that many of them are closed down and have no functional way of operating right now and cannot operate. These employees cannot operate from their homes. But those services were actually 5th, 6th, and 7th. It's also important to note healthcare and social assistance was 4th. So there doesn't seem to be any particular rhyme or reason for why certain areas receive more money or why certain industries receive more money. It seems that a lot of the discretion was left to the lenders, and they simply issued what they could on a rolling basis based on who was applying. There have been some rumblings that this is going to be done a bit more efficiently the second time around, and resources are going to be aggregated more according to need, but it's a bit too early to determine if that's going to be the case. We certainly hope that it will be.
Okay.
Now, in terms of the requirements under the Payroll Protection Program, in order to receive the full amount, which can be up to $10 million, this amount is determined based on a multiple of 2.5 times payroll. Now, all of this money can be forgiven either fully or in parts, but there are certain provisions that need to be taken under in order to do so, and I'll discuss those later. Another requirement was that because this is, done by the Small Business Administration, these companies have to have under 500 employees. Another big issue that's popped up in the news is that companies backed by venture capital and private equity firms get aggregated. So even though you're a startup with maybe 3 employees, if you are backed by one of these firms, you are aggregated into the larger portfolio of that VC or PE firm's ownership, and so you may not qualify.
So, Jordan, I'd like to focus on one of the things you mentioned, because I think it's probably, quite frankly, the most important for our listeners and our viewers today, is I understand these loans are supposed to be forgiven, but are there rules they have to follow? Is there documentation that they have to keep? Like, what should we be doing to make sure that that actually happens?
Absolutely. I'm going to go through each of the items that is necessary for loan forgiveness. And it's very important to understand businesses have to be able to support every single one of these numbers with documentation. So when you do apply for loan forgiveness, make sure you have some sort of documentation for every number that you're providing to your lender. The first element that is calculated within loan forgiveness is eligible costs. And it's listed here: the following costs and payments made during the 8-week period beginning on the date of first advance of loan funds are eligible for forgiveness. Now, that 8-week period, that doesn't begin to toll until the first advance is made. So even if you've been approved, it's not until that money is received in your bank account that that 8-week period starts to toll. The first part is payroll costs. It's fairly obvious. Then there's also mortgage interest.
Jordan, if I can ask you, what's included in payroll costs? I mean, is it just my salaries? How does that work?
It's a very important question. Payroll costs is much more than salary, and there's some flexibility here. The SBA rule states that payroll can include salary, wages, commissions, cash tips or equivalent, payment for vacation, parental, family, and medical or sick leave, group healthcare coverage, insurance premiums. There's a whole list of items that go just beyond salary. So it's important to get your attorneys or your accountants involved to make sure that you're maximizing these benefits. The other items that are included are mortgage interest, rent, and utilities. But these obligations have to have occurred prior to February 15th, 2020. The reason being, the SBA doesn't want you to suddenly incur a rent or a mortgage obligation just so that you could receive the loan and then pay that down. It has to be a prior obligation that's being paid for. Mortgage interest, rent, and utilities are forgivable for up to 25% of that PPP loan. Another way of looking at it is to say 75% of the loan forgiveness has to be for payroll costs. So whatever amount you receive, let's say you receive the maximum $10 million, you have to make sure that 75% of that amount is used for payroll. Only the other 25% can be used for these other items. The second number that will be looked at for loan forgiveness is full-time equivalent employees. And the SBA looks at this in a bit of a rolling average. They have 3 different periods that they look at. There's the 8-week forgiveness period that I just discussed. There's February 15th, 2019 to June 30th, 2019. Immediately, people would be curious, why are they looking at 2019? It's to give some sort of estimate as to normalcy for the business. So we're also looking at this same time period that we're in right now, back in 2019. And the third part is January 1st, 2020 to February 29th, 2020, which was the very beginning of when coronavirus hit and prior to these loans being issued. So we take the number of FTEs, full-time equivalent employees, for each payroll within that period, and then you average them. Now, an immediate question that is asked is, well, what's a full-time employee? There's actually no listed guidance on how to determine this, but we're recommending that businesses use the Affordable Care Act and look at that, which states that working 30 hours a week is full-time. The other option is to use your standard work day or week for the business. And obviously you'll need to provide some sort of documentation to show what that is, if that's other than 30 hours, but that will be accounted for. Now, it's also important to note that employees need not be actually working during these periods. They just have to have been paid as if they are. Again, the whole point is payroll protection. You can also include employees that were laid off or furloughed between February 15, 2020 and April 26, 2020, as if they were working during the forgiveness period. So it's understandable that a lot of employees have been laid off or furloughed now. That's fine. That can be taken into account. But these employees must be rehired or replaced by June 30th, 2020 in order to get the full reimbursement. The final item that the SBA looks at is excess wage reductions. Now, this step only applies if employees earning less than $100,000 have their salaries reduced by more than 25%. The point here is that the SBA doesn't want to encourage companies reducing salaries more than 25%, but then getting the benefit of that full payroll protection. The point is to keep people employed to the maximum extent possible under their full salary. If salaries haven't been reduced more than 25%, then this doesn't apply, and there's no reason to determine this amount. It also does not apply if reductions occurred between February 15, 2020 and April 26, 2020, and then the employee's wages were returned to the amount prior to the forgiveness period by no later than June 30th, 2020. These are the same determinants as if the employee were laid off. There's this sort of forgiveness period. If this step applies, then for each employee, you take the difference between the 75% of the previous annualized salary and their actual reduced annualized salary. And finally, the SBA has this calculation where you use all of the numbers that I just discussed. I highly recommend talking to your attorneys, talking to your accountants to make sure that this is accurate, and also making sure you have documentation to ensure that you have backup for every single one of these numbers. This is all added up and multiplied in certain ways, and finally at the bottom, you get the forgiveness amount, which, if you've done everything correctly according to SBA guidelines, you get the full amount forgiven.
Thanks, Jordan. If I'm getting the takeaway right, it's to make sure that you're absolutely documenting everything that you're doing and really paying attention to how your numbers and your payroll is being impacted, because those are going to be the 2 key points to loan forgiveness. Am I getting that right?
Yeah, that's absolutely critical. Make sure that the money is being used the way the SBA wants it, which is 75% for payroll costs. Again, there's some flexibility in terms of what payroll costs mean. And also that you document absolutely everything that you have. If you don't document it, it may not be forgiven. If it's not forgiven, you'll have to pay back that amount. The SBA is going to require a 1% interest rate. It's not too bad, but obviously you would prefer a grant and forgiveness over having to pay back a loan.
Sure, absolutely. Thanks, Jordan. With that, I'd like to turn over to Tamar. Tamar, in this environment, I've got to imagine there's going to be companies looking to take advantage of distressed assets, and quite frankly, just as often, there's going to be companies looking to back out of deals because situations have changed. So even if they're already under contract, they want to get out because of the value of those companies. what should our viewers be looking at in their contracts? Maybe language 3 months ago that was really just boilerplate and quite frankly, nobody thought twice about, that suddenly might be really important.
Hello, everyone. If you attended other webinars offered by Bressler as well as our colleagues, I'm sure you already heard a lot about force majeure clauses. Well, good news, we will not be focusing on just force majeure in this presentation. I will be speaking about materially adverse effect clauses. These clauses are called usually MAC clauses. Quite often, MAC clauses are relevant for businesses that have signed but not completed an agreement to purchase a target entity. So MAC clauses, materially adverse effect clauses, are very common in mergers and acquisitions deals, which are not very frequent now given pandemic, but there were a lot of M&A deals going around being signed either right before pandemic or during pandemic that have been affected by COVID-19. A critical legal issue that has arisen in recent days is whether COVID-19 pandemic may constitute a material adverse change or effect under existing agreements. Generally, such clauses appear, as I said, in acquisition, sale of goods, financing, and other commercial agreements, and are used to create parameters whereby a buyer of another company may terminate a transaction because of an event that negatively impacted the nature or value of the target product, company, or business. So, for example, Company A agreed to purchase Company B, and Company B was a restaurant, and because of the closures and inability to operate the business, their value has decreased. So most of the times now, the sellers are trying to get out of the M&A deals, claiming materially adverse effects. Now, a difference with force majeure clause that you probably hear more often about is that force majeure clauses are relevant for the businesses that already are operating and already have entered in commercial agreements with the counterparties, such as supply contracts, commercial contracts, etc. And the COVID outbreak has now impeded either party's ability to carry out the contractual obligations. In the context of M&A activities, MAC clauses apply before the closing of the deal, while the force majeure clauses apply in relation to the business and commercial contracts after completion and acquisition. So generally, MAC provisions have been interpreted really narrowly by courts, and specifically Delaware Chancery Court. There is only one case where Delaware Chancery Court actually allowed the seller to get out of the MAC clause. We would, just going to this next slide, I wanted to briefly overview some recent cases where the buyers attempted to get out of the mergers and they tried to terminate merger agreements. Some of these matters already settled, such as Victoria's Secret deal, and other three are still pending in different courts. To start with Bed Bath & Beyond purchase of 1-800-Flowers, this deal actually was set to close on March 30th, and under the deal, 1-800-Flowers was to pay $252 million for Bed Bath & Beyond, beyond personalized Molcom. The M&A agreement included MAC clause, of course, and the definition actually included potential disproportionate effect on the company. On March 23, exactly 7 days before the closing, 1-800 requested to delay the closing until April 30th. And then Bed Bath & Beyond sued in court, saying that this delay frustrates the purpose of the merger and claiming that 1-800-Flowers is wasting the proceeds for the deal. The sale agreement, as I said, contained material adverse effect clause that permitted 1-800-Flowers to terminate if there is an event that has disproportionate impact on Molcom. Bed Bath court papers actually said that 1-800-Flowers did not invoke the MAC clause. In cases where MAC clause is not invoked, sometimes the parties try to resort to either force majeure clauses or frustration of purpose. Actually, recently, Jordan and I worked on acquisition of a New York broker-dealer by a foreign investment firm, and MAC clause was the most heavily negotiated clause, and it took us almost this same time to negotiate this clause as drafting the actual agreement. Therefore, it is extremely important for our client or potential clients to review and revise existing MAC clauses to understand whether there is a potential for litigation and whether it is broad enough to protect the sellers. And next example is the Star Cinema Grill purchasing Cinemax. Almost the same type of dispute, but it is important, I think, to keep an eye at this dispute because the M&A deal was signed on March 10th. And as you all know, March 10th was already time where coronavirus was quite publicized, and both of the parties were aware of potential disproportionate effects that it would have. CMX, one of the parties that decided not to go forward with the deal, stated that although coronavirus generally was a known risk, the parties could not have anticipated its unprecedented scale or economic impact. The deal's basic purpose has been frustrated, and then Cinemax should not be forced to buy an indefinitely closed business, as they claim. So when we are talking about forcing to buy, this takes me to the last example, which is Victoria's Secret M&A deal. Here, Sizemore partners were buying Victoria's Secret. Almost same thing happened. As you know, all the stores were closed, employees were furloughed, and the companies had reached the deal for $525 million. After the so-called frustration of purpose, Sizemore partners sued in court, but they decided to abandon the litigation, not to engage in costly and distracting litigation to force a partnership with Sizemore. So these examples tell us the following, that for the existing dispute in each case, the analysis will depend on specific wording of the provision at issue and the effects on the particular company. During the negotiation of M&A agreements, both buyers and sellers should scrutinize the MAC definition and carve-outs to determine the appropriate risk allocation. And finally, we advise the sellers to maybe try to shift the risk of already known outbreaks, especially if the target's industry is disproportionately impacted.
Tamar, you mentioned the timing issue in the Star Cinemas matter. How much of that do you think is going to come into play in kind of matters going forward in terms of what was known and when it was known? Is that going to be important?
It will certainly be important because if, in the Cinemax matter, the agreement was concluded was signed on March 10th, and around March 10th, the parties were already quite aware of the potential materially adverse effects. And apparently the parties, according to the court documents, they negotiated around one of the risks, which would be the cinema closures.
So they already knew about that issue, and that's already being a huge, important topic that the court's addressing.
Exactly.
Got it. And Jordan, I want to turn to you for a second. It strikes me that a lot of these similar issues had to have been contemplated and litigated during September 11th. I mean, air travel was almost entirely shut down. Are you seeing this as similar, different? How do you anticipate this playing out?
Yeah, it's a good question. A lot of people are assuming that the Delaware Chancery Court in particular is going to treat this like 9/11. We think that this is categorically different from 9/11. You know, the Delaware Chancery Court previously didn't want to touch a lot of these clauses, including material adverse effect. And then as a result of 9/11, they did start to look at those clauses. You know, it remains to be seen. A lot of these cases are already settling, but I think the Delaware court is probably hesitant to look at them again, especially in the same way that they did as a result of 9/11. Firstly, outbreaks are not unprecedented or unexpected. As Tamar mentioned, we already put a lot of this information in these clauses. They already consider pandemics, outbreaks, diseases. And in fact, a lot of these businesses that are going to the Delaware Chancery Court right now to discuss these terms already have these clauses in there. They already discuss outbreaks or, some sort of viral episode that could be attributed to coronavirus. The way in which this is categorically different is that we have a government shutdown and an ongoing one. That's really what is not typically anticipated by these clauses. They don't expect people to be forced to be in their homes and businesses to be shut down for extended periods of time. So if the Delaware courts are going to look at this in a new way, that's what they would be looking at. Not in the sense that the diseases have never been conceived of before, but a government shutdown of this extent hasn't happened probably since 1918.
So it seems like between you and Tamar, we've got a pretty good understanding of kind of how the courts have been weighing in on these issues and how we anticipate them to weigh in on these issues. But I got to imagine a lot of the companies that you're talking about that are dealing with all of these issues, you're talking about contracts with partners that they've either worked with for years or are looking to work with going forward. I mean, Jordan, what should a creditor be looking at in terms of restructuring deals, workouts, things of that nature, before you're forced to go to litigation?
Great question. So what we recommend is simply renegotiating these deals. Rather than immediately giving notice that you're terminating the deal or going to court, it's a lot smarter to go back to the drawing table and speak to the other party and say, hey, look, this is affecting both of us. Here's how, here's why it's material. Let's agree to renegotiate this deal in a way that works for both of us. Now, in some cases, for example, that Sycamore Partners Victoria's Secret deal, they simply decided to drop the deal. And sometimes that makes sense, and that's fine as well. But immediately resorting to litigation is not necessarily the greatest idea. You should speak to your attorney because they'll know how to renegotiate. But don't immediately say, you know what, we don't like this deal. Everything has changed. Let's drop it. Let's sue. Another thing to think about is drafting clauses with pandemics in particular in mind. Previous clauses have said outbreaks, pandemics, but it says something very brief. Let's look at, for new deals, how we're going to describe those pandemics and how we're going to describe government shutdowns and how long do they have to be, how big of an issue do they have to be to cause materiality or to create some sort of differentiation in valuation and purchase price. So it's important to do your due diligence on, if you're purchasing a business, how is this affecting the business? How is this outbreak and government shutdown changing the value of the business that you're trying to purchase? And simply try and renegotiate first. That's not to say that you can't ultimately resort to litigation, but try and work something out because everyone's going through the same issues right now.
Sure, that makes sense. And I would think just valuations themselves are going to be very hard to do going forward. Your historical models aren't telling you much about government shutdowns for months and months at a time.
Right. I'd be very curious to see how valuations are handled, particularly on the accounting side more than the legal side. But it's definitely, that is certainly a clause within any of these contracts that needs to be handled differently and looked at with a fine-tooth comb.
Great. Thanks, Jordan. Before we turn back to Tamar, I want to give you your first CLE code, what everybody's here for. Make sure you get your credits. Code number 1 is corporate governance. That's corporate governance, and you can see that we put it on the notes. So if you click at the bottom of your screen, there is a notes section. So you'll see we'll put the codes up there so you have them going forward. And with that and that convenient segue, Tamar, I'm going to turn back to you. Jordan's walked us through a lot of the contractual issues, but what are our publicly traded companies doing? What do they have to do, and what should they be doing? I mean, are these roles changing now? And we'll have to unmute you. And now we can hear you.
Corporate governance issues are very broad, and we thought that we would focus on public disclosures mainly because some cases have already brought in federal courts where large IPOs did not disclose enough public information about the pandemic. So first of all, the boards of, let me switch this. The boards of publicly traded companies in particular, but also other kinds of organizations, must consider whether they are making sufficient public disclosures about the actual and expected impact of COVID-19 on their businesses and financial conditions. And they should evaluate, of course, whether they're obligated at all to publicly report regarding the results of pandemic, and in addition, file the reports with the Securities and Exchange Commission. Given the uncertainties of the COVID-19 pandemic and how quickly conditions can change, reporting companies must monitor new developments and also edit their reports wherever necessary. And also carefully consider the voluntary disclosure of information related to pandemic, balancing on the one hand the advantages of keeping the market informed, of course, and tempering negative impact and surprises with the drawbacks of disclosing incomplete or inaccurate information, because then that would require additional updates or corrections and creating continuing expectation of providing voluntary updates. One important information that I would like to note is the disclosure guidance by SEC, which is not obligatory, but very important to follow, from March 2020, whereby SEC stated that the evolving effects of COVID-19 and related risks would be facts and circumstances analysis, and most importantly, they should be specific to a company's situation. What does this mean? That the reporting company should ensure that risk factors refer to particular threats faced by its business and does not provide a simplistic and very broad description of recent events and general economic impacts. SEC also actually warns to refrain from trading prior to dissemination of this information. So we advise reporting companies to consider and evaluate their disclosure obligations relating
Tamara, I think you might be breaking up. There you go.
Is it okay now?
Yep, you're working perfect. Thank you.
Okay, perfect. So going back to risk factors, for example, if a reporting company has previously already included a risk factor regarding force majeure or other similar disruptive events that mentions public health issues, this does not mean that disclosure obligation has already been met. They will have to go back and now revise such risk factors in order to narrowly tailor them to the specific risks posed by COVID-19 to such company. And then also companies should consider whether they should include the appropriately tailored standalone COVID-19 related risk factor, as various reporting companies have already done actually. Although most reporting companies have already filed annual reports for 2019, such companies may encounter an obligation to update these risks. Moving on to material legal proceedings, not to take more time, we already spoke about this, that quite often in this day during pandemic, a lot of companies were faced by different lawsuits, such as breach of contract due to inability to perform caused by COVID-19, violation of material debt agreements, and more often also claims relating to companies' disclosures about misleading information. So this would also be a type of information that the company should disclose, as well as compensation matters. And when I mentioned that, what I meant was that reporting companies may need to consider disclosing rationale behind setting or adjusting any performance targets. Finally, they should ensure that disclosure controls and as well as the procedures over financial reporting are effective, of course, in current environments, and refrain from disclosing any material information that should be private, and not engage in any securities transactions with the public, including share buybacks and individual purchase or sales, unless such information has already been publicly disclosed.
So, Tamara, it sounds like, one, there is a lot of reporting that our public entities need to make sure that they're doing during this time. I mean, given all the changes that these things need to be reported, but at the same time that our public entities need to be really careful with exactly what they're reporting, making sure they're not, giving out information that is private and, especially about their employees. Are there kind of suggestions that you have for our public companies to make sure that they're doing this in the right manner?
Yes, of course. Especially in this day, investor scrutiny is really intensifying. We suggest actually four, there are more, but I can break it down to four main suggestions.
Please.
Which is avoiding, I think I'm breaking up again. Or,
you're good, go ahead.
Okay. Avoiding generic statements would be one. Then making use of safe harbors, informing investors if you are going to get sub-aid, for example, and finally keeping everyone on the same page. In next, I think we do have time to address each of those in a little bit of detail. So generic statements would be as specific as possible to stay, of course, in good graces of investors and regulators. It is not enough to simply state that COVID-19 may have an impact on the operations. This would be an extremely generic statement. This one factor is that the crisis impacts varying industries differently, right? The hospitality industry, for example, was affected by this differently than oil and gas industry. Therefore, one generic statement that they are expecting financial losses or already incurred such losses would not be enough. And the disclosure should be very specific to the type of industry that the public company is operating in. Now, moving on to making use of safe harbors. These may shield companies from liabilities when providing statements. Statements are also cautionary language. So it is important what type of terms and words will the companies use in these reports, right? So usually public companies are granted safe harbors from legal liabilities when they provide forward-looking statements, as long as these statements contain the terms such as we believe, we expect, we anticipate. And the idea is to allow the companies to provide insight to investors about where their business is heading, whether without being subject to litigation if certain developments don't actually come to pass. Now, moving on to, as I mentioned, investors, it is important to inform public and in general investors if you are getting aid. This was advised by Securities and Exchange Commission, which urged the companies to disclose if they're getting any kind of government aid, whether this is coronavirus aid or relief and security coming from Relief and Security Act and etc.
So if one of your public companies is getting took out Payroll Protection Act, that needs to be disclosed? Yeah.
Which is probably less likely that large IPO would be getting this type of aid, but if such happens, this needs to be disclosed in the reports. And it's also important to keep everyone on the same page. And what I mean by that is that as the pandemic and the economic impact plays out, companies may find themselves under huge pressure from investors and analysts to provide the updates beyond their most recent disclosures. The SEC regulation, Fair Disclosure, Reg FD as it is called, bars companies from releasing material non-public information to select recipients. And many companies actually have policies in place to comply with Reg FD. For example, they are called quiet periods, during which executives do not talk to analysts or investors while they are preparing their quarterly reports in order to prevent inadvertent disclosure of beforehand. So to summarize, one of many, of course, advices given to the IPOs would be, first of all, avoiding generic statements and be as specific as possible. But it is understandable that while they are very specific, they also do not want to sometimes disclose too much information, how much the company is suffering, without providing forward-looking statements for the future. Therefore, they can use the safe harbors and specific terms, inform the investors about the aid that they probably are given, and finally, keep everyone on the same page. To quickly give an example of a recent litigation, this was actually first securities litigation, the first coronavirus-related securities lawsuit in the US against a non-US company. This company is a real estate company operating in China. Phoenix Tree is the name. It was sued by a US investor, US shareholder in federal court, based on the allegations that the company's January 2020 IPO offering documents failed to disclose the impact of the outbreak on the company's residential real estate operations in China. With respect to this outbreak, actually, this company did disclose that they warned of the pandemic and stated that business could be adversely affected. But this specific shareholder who sued in federal court considered that this was a generic statement. As I said, it is important to avoid such generic statements because apparent coronavirus outbreak was already adversely affecting Phoenix's business because they operate leasing business, and their tenants already had contracted the virus in January in China, as we all know, and they lost employment and they were not able to pay the rent. Therefore, the lawsuit alleges that the statement should not have been generic because they already were well aware of the impact of the pandemic. With this, I will finalize the presentation and we can move over to IP issues.
All right, thanks, Tamar, appreciate it. And before we move over to Jessica, I'm gonna give us our second CLE code. So code number 1 was corporate governance, and code number 2 is intellectual property. And I'm gonna put that in the notes for those of you who didn't hear it. Code number 2 is intellectual property. And that kind of leads us into Jessica Gonzalez. And Jess, I'd like to talk to you about trademark issues. I know this isn't what all of our webinar viewers might first think of as a huge issue affected by the pandemic, but there's been pretty significant changes in my understanding about things you need to know when dealing with trademarks. Can you kind of bring us up to speed on what the trademark office is doing since COVID-19 has come into play?
Yep, absolutely. So as Evan stated, your intellectual property is probably not a high ticket item on your agenda. However, given that for most companies, the trademark tends to be one of the top 3 most valuable assets of a company. So it's important to take some time to speak about the various avenues of relief provided by the USPTO. So as the circumstances surrounding COVID-19 continue to evolve, so did the response from the USPTO. For anybody who's not familiar with the USPTO, it stands for the United States Patent and Trademark Office, and they are the governing agency that issues patent and trademark registrations in the US. Just for the purpose of today, I'll be focusing on the trademark deadlines and different areas of relief that the USPTO has offered. But just by way of background, it's important to note 2 facts about trademarks if you're not familiar with them. Trademarks are extremely time sensitive in the sense that their deadlines are statutorily based and strictly adhered to. And number 2 is a trademark will not mature to registration until you can provide proof of use in commerce. The United States is one of the very few countries that operates on a first to use system. So a lot of the litigation that takes place is really who used it first and where. So deadlines are very important. And so the common mistake that a lot of applicants tend to make is they file a trademark and they forget about it, wrongfully assuming that there's no other requirements down the road in order to perfect your trademark. So given that the current circumstances and the closing of non-essential businesses, the USPTO has recognized that trademark applicants and trademark owners may have a hard time adhering to a lot of these deadlines and providing proof of use of their mark in commerce. So under normal circumstances, if an applicant or an owner does not adhere to statutory deadlines, they risk having their trademark either abandoned if they were applying and it has not yet registered, or having their registration canceled after they've acquired registration. So as of March 16th, the USPTO responded pretty early on, and the first avenue of relief that they provided was pushing back or waiving the fees for certain reinstating certain trademark filings. So the USPTO determined that the circumstances rose to the level of an extraordinary situation. This is extremely rare for the USPTO to take such an approach. And so it was a very big deal. So the first thing that they did was they waived petition fees associated with reviving your trademark or reinstating your trademark if it was canceled due to the owner's inability to file on time. So as we stated in the beginning, deadlines are so important, and if they're not adhered to, they can really lead to you losing your IP rights or just losing your application, even if it was super close to being registered. So it's important to know that there are two distinct forms for reinstating your trademark application or reviving your trademark registration. So make sure that you're using or your clients are using the correct form. So for abandoned applications, the proper form is the petition to revive an abandoned application. If your registration has been canceled or if it was expired, then you have to file a petition to the director itself. In both cases, the petition must include a statement detailing how the failure to respond to the USPTO was due to the effects of the coronavirus outbreak. And you have 2 months. So from the moment that you receive notice that, hey, your mark has been abandoned or your registration has been canceled, you have 2 months then to petition the USPTO, and you don't have to pay the fee, which is typically $100. And for a lot of small companies, that could be a pretty large amount, but for larger companies, it may not seem like so much. So here. So as COVID continued to proliferate, the USPTO further extended various forms of relief. And up until the signing of the CARES Act, the USPTO actually did not have any authority to extend any deadlines because they're set by the statute. So the director needed direct authority to be able to move deadlines. So on March 31st, the CARES Act did provide the director with a temporary authority to toll or waive certain parts of the application process if it's determined that an applicant or an owner was materially affected by COVID, such that the circumstances did not allow them to file or pay for their application on time. It's important to note that there are only certain filings. So the USPTO took this on a very case-by-case basis. There's only certain types of filings that are actually able to be extended with their timelines. This is very different from a lot of intellectual property offices around the world that have actually just taken a blanket approach and said, you know, every deadline is waived for 30 days. The USPTO has not done that. They've only taken it case by case. So the following are the filings that are afforded that you can see right here. So they include a response to an office action, a statement of use, any sort of priority filings based on foreign registrations, various types of renewals, or affidavits of use or excusable non-use.
So, Jess, let me ask you, the applicants, what are they actually filing? Is it a separate application to extend? Is there a different process? Kind of, how does this actually physically work?
Sure. So there is no form. In order for you to take advantage of these extensions, they're automatically applied. So April 28th, they extended it. So any filing that was due between, March, I believe it was March 16th, is now extended to June 1st. So if your deadline fell within any of those between March and June, then you have an extra 30 days to file whatever response that you had to file. But there's not a separate form. It's just when you actually do the filing, you have to provide a statement that you were affected by it materially. And the material, those qualifications, as are listed here, include office closures, travel delays, personal illness of family, perhaps inability to reach out to your attorney as well. And it's not all encompassing, but they do have language there for similar circumstances. So as long as you can actually provide the USPTO with a reasonable basis for why you were not able to, you should be okay. But I do want to caution everybody who may have clients who may just want to take advantage of this, but who were actually able to file, that you're still certifying under oath that everything that you are putting forth is true to the best of your belief. So if you are, if your clients do want to take advantage of this, I recommend confirming that they've actually been affected and that it falls under one of these qualifying conditions.
Certainly seems like a theme we've been running through kind of with all of our presenters, that documenting everything that you do and why you have to do it is incredibly important. Does that kind of follow through with trademarks, Jessica?
Oh, absolutely. With trademarks, I always tell people, keep your receipts all the time. And so it is important for the USPTO to have communication with them. I err on the side of caution, so I made sure that I reached out to trademark examiners who were assigned to some of my clients' applications, just to reassure them that we will be filing, but it is going to take some time within this time frame that has been provided. So I do recommend taking further precautions, just because these deadlines are not automatically applied. The USPTO is a very archaic system, and so this isn't something that's automatically going to happen. The examiner really is the one that's the gatekeeper and who you really have to inform. So I just wanted to tell everybody that it's not an automatic suspension of waivers or filings, and that they're not automatically applied as well. But I also, just wrapping up, that if you also have trademarks outside of the US, whether in Europe, the UK, China, South America, a lot of those offices have taken similar approaches, but more broad approaches. So also be sure that you're keeping up with deadlines over there. And as this continues to proliferate, I anticipate the USPTO will continue to delay certain timelines and waive certain fees. They've been issuing updates every 2 weeks, and so I will make sure that all of our clients are kept apprised of these various avenues of relief as they continue to develop.
And you can always find those updates. I know whenever you send out an alert, that our clients can find those on our website as well, correct?
Yep, correct.
And Jess, I got to ask you, I'm curious, because you mentioned some very enumerated types of filings that are covered under these new regulations. Are there filings that we should be aware of that are specifically not covered under those new regulations? So, you got to make sure you get them in no matter what.
Yeah, sure. That goes back to the whole, this is not automatic across the board. So one thing is, if you are in an opposition proceeding, a cancellation proceeding, which is, litigation, but for trademarks before the Trademark Trial and Appeal Board, those deadlines have not been extended. So the Trademark Trial and Appeal Board is leaving it to the parties to decide for themselves, if they want to extend discovery or extend the time to answer, but they have not taken that approach. And it makes sense, because typically they don't get too involved unless necessary. So, making sure that you're in communication with your opposing counsel, and, keeping them apprised really of your situation, your client's situation. I think, at least I've had the experience with opposing counsel, that everybody has been pretty sympathetic and have been pretty willing to extend various deadlines.
Yeah, I think that's a great point. And, I know Jordan talked earlier about, when we can avoid litigation, we want to try and work with, especially companies that we have relationships with and have had good relationships in the past. But the theme of document, I think carries forward. Just because you're having a good relationship now and everybody's on board with extending deadlines doesn't mean you're not going to need all of that documentation in the future. If you end up in litigation, you're going to want to be able to show exactly why one of those contractual clauses Tamar mentioned is necessary and is impacted by COVID-19. You're going to need to show, exactly what happened with your company, why your stores were shut down. Was it by choice? Was it by government regulation? Kind of all of these things are going to be important to make sure you're keeping track of going forward. And that, quite frankly, don't just get put in a folder and lost somewhere, but are really kept up to date and organized, because I think we all too often have a tendency to say, okay, I'll write this note now and I'll remember it later, but really staying organized and documented, I think, is really important with everything that all of our presenters have been talking about. All right, well, with that, I think we are towards the end of our webinar. I want to thank everybody, our presenters, for doing such a great job. I'd like to thank everyone who listened into the webinar for joining us. For those of you who didn't hear it earlier, our 2 CLE codes are once again code 1, corporate governance, that's corporate governance, and code 2 is intellectual property. That's intellectual property. So we've got corporate governance and intellectual property, which were really the themes and the highlights of today's presentation. And I'd be remiss if I didn't mention and remind everyone that next week we'll be back here with another webinar. We've got some of our principals, Mike Ostrowski, Karen Murphy, and Ron Campione, who are going to be talking about real estate issues, dealing with leases, as well as other contractual issues and what they see coming down the pike, how the coronavirus and COVID-19 are truly impacting those industries, and what you as businesses need to know. What do you want to see? What do you want to make sure you're paying attention to, and how should you be handling these issues? So I'd formally invite you all to join us next week. Thank everyone again for their time, and everyone have a great afternoon and stay safe and healthy. Thanks, everybody.